Thank you, Anthony. You can go to lawandcrime.com to learn a little bit more about those stories and other legal and crime stories of the day. But I want to take a minute and talk a little bit more about that Sidney Loof case, a really disturbing case. But I want to bring on my very special guest, juvenile court judge and attorney Ashley Willcott. Ashley, it's great to have you back here on Law and Crime.
Thank you. Good to see you.
So this Loof case, I mean, this sounds like a nightmare. Anybody tries to do online dating, this is the worst thing that you possibly can hear of happening. What do you make of it?
It's a terrible case. And so I think that those who have been watching or familiar with the story to know that this is somebody who went on Tinder. A lot of people go on Tinder to meet someone, and she was excited about the date. At least that's what she's told her friends, and her friends have said. She goes on this date, and then she's never to be heard from. And long story short, turns out she was dismembered. So it's not only a horrible murder, it's really a horrific, gruesome, heinous murder and what's happened to her.
I'm trying to understand what the relationship here is between the defendants, their boyfriend, girlfriend, and how did they target Sidney? Do we know anything about that?
I don't know anything about that. It's interesting you say that, because the first connection that law enforcement made was to the female partner in crime. I don't know if it's a girlfriend. I don't know how they're related or what their relationship is, but they started with her. They got a search warrant for the home, and then you have both of these individuals defendants. So to me, it's not yet clear exactly what their relationship is. And then you have to wonder, is the relationship one that is based on criminal activity, like attracts like, and they happen to be two people who are in it together to commit heinous crimes? I don't know. We don't know yet. We're going to have to watch.
I've read that it seems like one of them is taking the blame while the other one is saying, I just cleaned it up. Is that what you heard?
Yeah, that's what I heard as well. I don't buy it. I don't believe it. I don't think anyone's that innocent if they're at all involved. But that's what I had understood that the one was saying and the other was saying.
And what, in your opinion, from what we know so far in this case, is the strongest evidence against them? Is it the security camera footage of them collecting tools in the night in question to ultimately kill and dismember this young woman?
I think it's that, but I think there's also a lot of little pieces that go together. So, for instance, the report that came in was this apartment smelled of bleach, right? And we know that that's a common thing used to clean up blood and clean up messes. So you have this smell of bleach. Then you have the security of video. You have the search of the home. So there are lots of little different pieces that I think prosecution could effectively put together to say this is what happened and these are the two individuals who did it. Having said that, there's no smoking gun in this case that I've heard of yet or seen.
What a sad case. What a really sad state of affairs. It's a shame. And we're going to cover more of it as soon as we learn more details about it. But, man, this is a worse nightmare when you hear about dangers of online dating. Really, really sad. So, Ashley, stand by. We want to switch gears. We're going to talk now about the Wallace Bradsher case. This is one of our main trials of the day. We're waiting for a live feed, and we expect today to be very interesting because the defendant, who's representing himself, will begin his case. The defendant, Wallace Bradsher, a former district attorney, is on trial for allegedly operating a criminal scheme where he hired another district attorney's wife and paid her $48,000 for work she didn't do. As if that wasn't bad enough, he's also been accused of trying to cover up the scheme and place the blame on other people. Throughout this case, he's had the opportunity to cross-examine key people who have testified against him, including, who we've been showing you pictures, Cindy Blitzer, the woman who's at the center of this case, as well as her husband, Craig Blitzer, who is his co-conspirator. There he is right there. Craig Blitzer already pled guilty to one misdemeanor count in connection with this alleged scheme, and he waits to be sentenced after the conclusion of this case. Mr. Bradsher, who's married, and his wife Pam worked in Craig Blitzer's office. He's also a father to many children. He faces up to 18 years in prison if convicted. There's a lot on the line here in this tale of greed, corruption, and public mistrust. I mean, basically, you have a district attorney who's accused of stealing or helping to facilitate stealing taxpayer money. This is a very big accusations thrown against them, very big charges. So what we want to do right now is we wait for the live feed. I want to play you the testimony of Craig Blitzer, as I said, his co-conspirator. And this was one of the most interesting aspects of this case because you have the defendant who's representing himself having the ability to cross-examine his co-conspirator. Let's play you some of that cross-examination right now. What a unique state of affairs where you have a defendant who's representing himself having the ability to cross-examine not only his accuser, but his co-conspirator. Let's talk a little bit more about it with Ashley Willcott. So I think this is a very interesting situation when you have that, not only a district attorney who's representing himself, but having the ability to cross-examine this co-conspirator. How's the jury supposed to believe one person over the other when it's a he said, you told me to lie, you told me this, you told me that? I mean, honestly, what do you do in that situation if you're sitting on the jury?
That's right, Jesse. This is the blame game, so they're going to blame each other. But I have to say this. I think a couple things go into how a jury makes a decision or what they may be paying attention to. First, I've said since the beginning of this case, it really surprises me that he's representing himself, because I just feel like you're going to be emotional about it. It's about you. It's life in prison. So it's better to have an attorney representing you. Having said that, now he's trying to discredit and blame him and say it's your fault. Didn't I tell you this? Didn't I do that? I think the credibility is going to become the issue, and the credibility of this case, not only of the witness, but also of the defendant who's serving as his own attorney. So this is a little bit of an unusual, weird beast, so to speak.
Do you think he's doing a good job representing himself? I mean, other than, things here and there. I mean, today he is going to begin his case. We expect him to potentially take the stand in a kind of Q&A format. How do you think he's doing so far, and what do you think that's going to be like if he actually does take the stand?
So I've watched a lot of this trial. I have found in trying to follow his questioning and the point of his questioning that it is a little convoluted for me. And so sometimes I feel like it's not until 15, 20 minutes into his questioning that I understand or grasp exactly what his point is, what he's trying to prove. And so I feel like that may hurt his case.
Because if it's difficult for us to follow, and I agree with you, imagine for the jury sitting there and trying to put pieces together and what it'll be like. But then again, this is a unique case where he's trying to tell his story, and it'll be very interesting to see what his story ultimately is during maybe his own direct examination of himself and during his closing argument. So here's what we're going to do. We're going to continue playing some more of Craig Blitzer's cross-examination, because this is really, if not the most important testimony, critical testimony. Him and his wife were both key witnesses in this case. So let's play a little bit more of the cross-examination of Craig Blitzer. Again, trying to understand what was his wife really doing in that office, and was she getting paid for work that she actually did or not? Let's look.
Back up.
Two district attorneys battling it out in the courtroom, blaming one another. That's a very interesting case. Let's bring in Ashley Willcott, because I have a very important question to ask Ashley. Ashley, I'm going to ask you the same question I asked anybody in this case. Wallace Bradsher is not accused of stealing money himself, but allowing this other district attorney's wife to take the money and trying to cover it up. What is his incentive in this scheme? I can't understand it. So if I'm sitting on the jury, why would he make a concerted effort not to have her resign, to say he has unfettered discretion, and for her to keep on collecting checks and cashing them for work she didn't do?
Well, my understanding is it was a wife swap. So the benefit to him is he has his wife working for the other DA, and they as a couple are collecting that income. So it's an easy way to employ two wives to get more income for the household without them. I'm not saying they're not qualified, but perhaps not being qualified, not doing the work. It's a cush job. Who wouldn't want $48,000 for their spouse doing nothing? It's income into the household.
Is it just quid pro quo, though? Hey, listen, Pam Bradsher is going to work at your office. She was doing a good job by all accounts. She was doing her work and getting paid for it. But is it almost like, hey, I don't want you having something on me. My wife is working for you. I'm going to take care of your wife. I mean, it's so bizarre that you have the Blitzers now pointing the finger at Bradsher when it seems Bradsher is accused of trying to help them out.
Right. I agree. It is bizarre. It is a weird thing. But I think the reality is they said, okay, well, you're going to let each wife work for the respective other DA and collect that income for the family. And now I think that what Bradsher's going to do is say, hey, listen, maybe it was mismanagement at worst. This Jay was supposed to supervise, pay attention. He failed. He dropped the ball. That doesn't impose any criminal liability on me just because it was mismanaged. I think that's going to be his position or defense.
Judge John Stoltz, this Jay Stoltz, as you keep hearing him in this case, he testified yesterday that I no longer had a supervisor role in terms of Cindy Blitzer's hours. I spoke to Wallace Bradsher, and Wallace Bradsher, I said to him, I have too much on my plate. I can't deal with it. Wallace Bradsher says, don't worry, I'll take care of it. I'll assign it to someone else. Well, when this whole SBI investigation came forward, Wallace Bradsher called in John Stoltz and he said, what's going on with their hours? And he says, I don't know. I'm not working on them anymore. He goes, yeah, you're still responsible for them. And John Stoltz was taken aback, said, whoa, we had a conversation about that. According to Mr. Stoltz, he then was authorized by Bradsher to release all of Cindy's hours to the AOC and confirmed that she was, in fact, working those hours when, in fact, we know she really wasn't. That was a very big claim by that witness.
Absolutely. And you know, even after that claim, Bradsher's sticking by, hey, Jay was supposed to be supervising and was doing this, and it was his responsibility. So I'm very intrigued and fascinated by what is his testimony going to be? What is he going to say on the stand? I hope for his sake that whatever his defense is and testimony on the stand, he has it well organized to paint a picture for the jury, because I think he's failed to connect dots through the witnesses at this point.
Well, hopefully, I don't know if he's watching Law&Crime, but, you know, there you go. Some free advice right there. Okay, we are waiting. I think I see a courtroom feed, but we see the seal. Nothing has happened just yet. As soon as we have a live feed, as soon as trial begins, we'll make sure to jump into that courtroom. In the meantime, we're recapping some of the most critical testimony, and that is right now Craig Blitzer, this co-conspirator. And when he was cross-examined by Wallace Bradsher, we had a better understanding of their relationship and what each party knew about what Cindy Blitzer was ultimately up to. So let's play you some more of this cross-examination right now. Some critical testimony there in the Wallace Bradsher case out of North Carolina. A district attorney, I should say a former district attorney, who is on trial for multiple felonies and a misdemeanor count, could face 18 years in prison for allegedly operating a scheme with that witness to hire each other's wives for no-show jobs. Well, I should say that Wallace Bradsher is really the one who's accused of hiring Cindy Blitzer, Craig Blitzer's wife, and paying her $48,000 for work she didn't do. Pam Bradsher, Wallace Bradsher's wife, worked for Craig Blitzer, but by all accounts, she put in her hours properly and was doing the work. But, again, Mr. Blitzer and Mr. Bradsher are both accused of conspiring in this illegal scheme. Let's bring back on Ashley Willcott. Ashley, as we wait for the live feed in the courtroom, I'm trying to understand a little bit about what Wallace Bradsher is saying to defend himself. Is he pointing the finger at Cindy Blitzer and Craig Blitzer and saying they're the ones who came up with this scheme? It's all their fault and I never authorized or tried to hide anything?
That's what I'm a little confused about. I think that is what he's trying to claim, and that he did not, in fact, participate knowingly in this scheme. I think that's where he's going with this particular line of questions.
Is that believable overall as the head of the office, that he wouldn't know that one of his employees, let alone not just an employee, but somebody who he affirmatively got into that office through that, as I think they call it, an employee exchange program or employee sharing program. I forgot what the exact terminology is. But it wasn't just a random person he didn't know. He knows Craig Blitzer. He knows Cindy Blitzer. They purposely had each other's wives work in their respective offices. So is it so believable that he didn't know at all what was going on here? And she admitted on the stand she knew what she was doing was wrong.
Right. Do I find it believable? Not at all. It doesn't hold any water for me, because you have a duty imposed on you as the district attorney to manage your office, to run your office, to carry out justice, and that includes all of those pieces. So I don't find it credible. I have to admit and state I am certain that there are people in every industry that have management responsibilities that do not pay attention, that are not aware. I don't think that's true in this case. I think he knew.
Can't wait for him to hopefully take the stand and explain this whole story. I'm looking forward to that if that happens. We do believe it'll be a Q&A kind of format where he asks a question of himself and answers that question. He wanted to give a long narrative, but the judge came forward with the Q&A format instead. We are carefully keeping an eye on the courtroom. As soon as it begins, we'll make sure to jump in there. But before we talk more about the Wallace Bradsher case, we want to preview another case that we're going to be covering here on Law and Crime, another case that we will be live in today. It's a case out of Kentucky, and it is a sad one. It is about a Marine who was trying to save his wife. Take a look.
The Kentucky trial of the shooting death of a Marine is set to begin. 26-year-old Quincinio Canada and 34-year-old Dewan Malazam are charged with murder and assault for an incident outside a bar in 2014. The two men allegedly approached Corporal Jonathan Price and his wife Megan when one of them tried to snatch Megan's purse. Jonathan got involved, a fight started, and the corporal was fatally shot in the back. Megan suffered a non-fatal bullet wound to her leg. Both men are also charged for a robbery 6 days prior to the Price shooting. Law enforcement connected them to both crimes by identifying the .45 caliber handgun used in the robbery and the shooting. For Law and Crime, I'm Rachel Stockman.
Thank you, Rachel. That was a great report about a really sad case that we will be covering here on Law and Crime, and we will cover it gavel to gavel. But that is not the only case that we're focusing on, because our main trial right now is one that we're live in, and that is the Wallace Bradsher courtroom. That is the defendant himself, that man right there. Who knows what's going on in his mind right now? I'm wondering whether or not he is planning to take the stand. He's representing himself, and it became a question yesterday about if he took the stand, how would that format work out? It seems that it would be a Q&A format where he would literally go up on the stand, read a question, and then answer it. It provides the jury with his narrative of what happened in this bizarre scheme. We have a live audio feed we have an audio feed in the courtroom. Actually, we're going to wait on that. I think we're still working on it. But the defense, we just got an update. The defense has rested his case. Wow, this is a shocker. Wow, this is a surprise considering what just happened. Let's listen in. Let's see what's going on. Okay, I never like to say that I'm surprised, but I am very surprised by this. We anticipated that the defendant who's representing himself would put on a case, would present witnesses, would maybe even take the stand himself. Well, he just rested, and I'm a bit confused by this. Hopefully Ashley Willcott can help explain it. Are you surprised? What's going on here?
Well, I'm a little surprised as well that he did not take the stand, because you will note in all of the questioning of all the other witnesses, he, in my opinion, repeatedly was trying to place blame or responsibility on other individuals and claim he didn't have knowledge, he wasn't directly responsible, and therefore he cannot be found guilty of these criminal acts. I really thought for certain that he would testify on his own behalf to tell his story to the jury. Now, what I'm going to assume is that he believes that he has presented enough evidence through cross-examination to convince at least one juror that there's reasonable doubt. He must be secure in that to rest and say there's no need for me to present any additional evidence or testify on my own behalf. I am surprised.
And maybe his closing argument really would have been what he would have said on the stand. It gives him, again, a chance to tell his narrative. But there's something, a conversation going on in the courtroom right now, so let's listen in live. Okay, so if I was hearing that correctly, Wallace Bradsher's motions to dismiss some of the charges, if not all of the charges, have been denied. Let's bring back on Ashley Willcott. Surprised by that? Those motions to dismiss were denied?
Well, I'm not surprised he made the motions. He made them on two grounds. One is to say at the conclusion of the state's evidence, grounds were not proven for the indictment, and so those should be dismissed because there was insufficient evidence on those particular grounds alleged. The second thing he said is that basically these indictments have been drafted in a way to use misdemeanor language, even though it's a felony. So at a minimum, Judge, I want you to reduce the charge from a felony charge to a misdemeanor charge. Actually, pretty creative argument. Now, I'm surprised the judge did not grant any motions so quickly. To me, this means the judge, law clerk, someone at the court had already done the research so that the judge knew if these motions were made, he would find that there was sufficient evidence not to dismiss. Typically, I see a judge perhaps take a recess, right, and say, I need an opportunity to look at the evidence, to do some research, to ensure that I'm making the right finding, and we'll come back in an hour. In this case, I think he'd already thought of it ahead of time and looked at the evidence to say, nope, these motions would be denied if made.
But for all of our viewers, they shouldn't take that as a sign of what the jury will ultimately decide, correct? I mean, obviously we need closing arguments, jury instructions, but even if a judge finds that's a different standard, correct?
Right, right. No, Jesse, excellent point. It is a different standard, and I do not think that it affects what a jury does or doesn't do with their verdict.
All right, well, this is one to watch. You never like seeing attorneys get in trouble, let alone elected district attorneys and he is facing some pretty serious counts and up to 18 years in prison if convicted. But as we wait to go back into the courtroom now that they're in recess and preparing the afternoon's jury instructions and then closing arguments, I want to play some more of the testimony of Craig Blitzer, a key witness in this case, the co-conspirator with Wallace Bradsher. This is when he gets cross-examined by the defendant about when Mr. Blitzer became a person of interest in the SBI investigation. Let's take a look at that right now. Okay, so we're recapping some of the most critical testimony there in the Wallace Bradsher courtroom as we wait for the conclusion of this case, and we are surprised. We thought that Wallace Bradsher, the defendant, was going to at least provide some sort of defense, in the sense that maybe call some witnesses. Originally, we thought he was going to be calling about 100 witnesses, thought his case would last about 4 or 5 days. We even thought that he was going to be taking the stand himself. There was a whole conversation yesterday about what taking the stand would look like. So we tried to analyze why that might happen. Let's bring back on Ashley Willcott. And Ashley made the great point about the advantages and disadvantages of him putting on the case, and that perhaps he was able to tell his story through cross-examination. And we also talked about the idea that in his closing argument, maybe that would allow him the opportunity to really tell his story. And again, Ashley, if he was going to do a Q&A format on the stand, and then right after do his closing argument, I guess it would have been a bit repetitive if he was basically making the same points. So what do you imagine a closing argument by Wallace Bradsher to look like?
Well, keep in mind that a closing argument can only be based on any facts that are properly in evidence before the court and the jury. So whatever his closing argument will be, it has to be based on admissible facts that have already been argued. So he is going to have to tailor the narrative that he wants to tell the jury around everything that's already been proven. And I think that that, again, is going to rest on his position that he was not responsible for supervising the individual, that he was not aware of a lot of what occurred and what happened, and that it was not something that he made the decisions on. But I think the problem with that argument or narrative is he had the authority and responsibility to oversee her and know what was going on and ensure that there was no work being done for income and somebody going to nursing school while they're being paid for a full-time job.
There's a lot more questions than we have answers. Do you imagine that if he took the stand himself, he might have had a last-minute concern about cross-examination, what might have been asked of him? He
has not acted in a way to me, for me to think that he would have any concerns about testifying, because certainly he has been very tenacious in his cross-examination. So I would think personality-wise, he wouldn't have a problem in the world going ahead and testifying. The reason that I understand the judge said, okay, he would have to ask questions of himself and then answer them is because you want the prosecution to have the opportunity to object to a question. That's much easier to do when there are questions versus just a long narrative. I still stand by, I'm assuming, I don't know, this is just my opinion, so take it for what it's worth. I just think that the only reason he would not testify is if because he believes every point he wants to make in closing to paint the story, to tell the story, to give his narrative has already been made through cross-examination of the witnesses.
Listen, I value your opinion, and you might be right. I think you would agree that if that's all true, then really his closing argument needs to tie it nicely together because, as you said perfectly, it is very confusing, particularly when he tried to cross-examine Craig Blitzer and asking him about a timeline and dates and what was said and when, how this all tied into the framework of the case. I was stuck here a lot of times remembering the big issue here, what he's on trial for and what we're talking about, because that can somehow be lost. So again, this man is on trial for allegedly operating an illegal scheme with Craig Blitzer to hire Craig Blitzer's wife and pay her for a job that she didn't do. And that is ultimately the bottom line. And trying to understand everything else and who knew what and what was said to him, it can get a little confusing. So I imagine in his closing, he's got to tie it closer together.
Yeah, Jesse, if I could go to one point that you mentioned, and that was the dates, the confusion when he questioned Blitzer. I felt like Blitzer was responding in a way that really made Bradsher look bad. So to me, he made it sound like, I don't know what you're talking about. It wasn't in 2016. I think you're wrong. And a lot of his responses to me did that. The other thing I noted is that Bradsher drew a lot of objections based on hearsay that were sustained. And that means to anybody watching who may not watch a lot of trials or is new to the show that the state is right. And he shouldn't have asked the question the way that he asked it. And to me, again, a number of objections. Does that make that person look bad to the jury? Maybe. I just wonder how many of these things are going to make the jury feel like he's not credible, he's not believable, he looks bad to them, and therefore they're going to convict. I don't know.
Well, as with everything, we'll have to see. We'll have to see. Let's play a little bit more of the testimony of Craig Blitzer. And this is, again, this conversation is about how much Cindy was paid. Another big issue in this case because, again, she collected $48,000 working at Bradsher's office, and she had to return that in the form of restitution. She's not being charged in connection with this case. Her husband pled guilty to a misdemeanor charge. We'll have to see what his sentence will ultimately be. But this point is when Bradsher starts asking Blitzer what salary Cindy had when she was originally working at Blitzer's office. Take a look. Okay, so that's some of the testimony of Craig Blitzer, one of the key witnesses in the Wallace Bradsher case, is co-conspirator in this bizarre, allegedly illegal scheme to hire Mr. Blitzer's wife and pay her $48,000 for work that she never did. That's a big crime. That's a big accusation. Mr. Bradsher faces, well, let's see, 6 felonies and 1 misdemeanor count. That's up to 18 years in prison. He's been representing himself. Today we learned he will not put on a defense. He will not call any witnesses. He will not testify himself, but he will provide a closing argument. And hopefully, as we talked about earlier, that will be the opportunity for him to tie in all of the points that he made under cross-examination. But can he do that? Will it be successful? Let's bring back on Ashley Willcott. Ashley, we were talking a little bit during the break about, in his opening statement, he went on and on about him being a great attorney, how he brought a lot of success to the district, a high conviction rate, talked about hiring his wife, Pam Bradsher, how everything was okay. Then this ethics rule came down, said that she couldn't be in his office. It's all well and good. What I didn't hear so much was a groundwork or a blueprint of where he was going in the case about how he's not responsible for Cindy Blitzer collecting paychecks for work she didn't do. I didn't hear that. I didn't hear anything where he was absolving himself of responsibility. He really needs to do that under closing, correct?
Right. So I did not hear anything in opening either. So keep in mind at this point, All he needs is one jury member, one juror who says there's reasonable doubt that he committed these crimes, and then he will not be convicted. So I believe that what he needs to do, and what hopefully he will do in closing for his own sake, is now say, based on the evidence presented, here's the reasonable doubt. Here's what I didn't do. Here's what I wasn't responsible for. The supervising, I didn't have knowledge of this. It was delegated to someone else, so I did not knowingly do anything that amounts to a crime. And if he can convince one juror of that, then he won't be convicted. And I think that's his job, and that's what he's got to do in his closing argument to be successful.
Well, we will cover it here on Law and Crime, but before we go back into the Wallace Bradsher courtroom, we want to play you the top crime stories of the day here on Law and Crime.
Law and Crime.
Thank you, Anthony. Those are some great stories. You can learn more about them on lawandcrime.com. And go to lawandcrime.com. You can learn a little bit more about political stories, legal stories, entertainment stories, everything in the law and everything that's happening right now. And speaking of right now, we are not only just covering the Wallace Bradsher case out of North Carolina, but we're also going to go over to Kentucky because we have a brand new case that we're going to be covering. And this is a really sad one. It's a tragic case, a senseless death of a Marine who by all accounts was just trying to protect his wife. Let's play you a quick report about that.
The Kentucky trial of the shooting death of Marine is set to begin. 26-year-old Quincinio Canada and 34-year-old Dewan Malazam are charged with murder and assault for an incident outside a bar in 2014. The two men allegedly approached Corporal Jonathan Price and his wife Megan when one of them tried to snatch Megan's purse. Jonathan got involved. A fight started, and the corporal was fatally shot in the back. Megan suffered a non-fatal bullet wound to her leg. Both men are also charged for a robbery 6 days prior to the Price shooting. Law enforcement connected them to both crimes by identifying the .45 caliber handgun used in the robbery and the shooting. For Law and Crime, I'm Rachel Stockman.
Thank you, Rachel, for that report. We are live, actually, in that Kentucky courtroom right now for the case of these two men where the death penalty is at stake. I want to bring on real quick Ashley Willcott. So we've been talking about Bradsher and a case about public corruption, but now let's get back to reality here with a very, very serious case. And I can't help but just think about the tragic nature of it, a Marine who, by all accounts, was just trying to save his wife from a robbery. What do you think about this case?
Yeah, this is a terrible case. It's one of those circumstances where it was an armed robbery and they were trying to take it, and he did get killed as a result. And it's not only that aspect of it, as often happens in our system of justice. This happened 4 years ago, and so not only was he killed, it's been 4 years since then that they're finally going to trial against these two defendants, and that's a lot of emotional distress for the family and victims in this case.
The delay in this capital murder case has been one of the main issues of it. Why has it taken so long to finally be in this courtroom?
Well, it's, anytime, especially with a capital murder case, you want everything to go correctly and well. And defense often, and in this case, it's my understanding is the case as well, makes motions to ensure that they've done everything they can to find any grounds to make a motion to dismiss, to have all of the evidence that the state has, and to be very well prepared to try the case. And so necessarily, sometimes the wheels of justice are slow.
Yeah, it's interesting. As I was reading about this case, it seemed that there was a big issue. The judge herself is quite the character in this case. She was very, very frustrated that it kept being delayed and delayed and delayed. In fact, she wanted, I think, a change of how these capital murder cases are handled from now on. And she wants 30-day status conferences so that there's no more delays in this. This shouldn't happen. I am being told that we have audio in the courtroom right now. So let's go live in Kentucky for this brand new case here on Law and Crime. Two men are going to be on trial for the murder of a Marine from what appeared to be a senseless robbery gone wrong, a really sad case, and we're waiting for the opening statements from both the prosecution and the defense. Again, I'm here with Ashley Willcott. I'm trying to understand what the defense will do here. What do you think they will argue?
Well, I I don't know. I know part of the reason that was reported the long continuances and delays is because these are public defenders who had very high caseloads and they wanted to be adequately prepared. I do not have any insight as to what the real defense is going to be, other than they didn't have the intent to kill. But I don't really know how that's going to be brought in. So I'm interested to see. It's going to be an interesting defense.
From what I've read, the prosecution has a pretty strong case identifying the two men as the perpetrators of this crime, and these guys seem to have been in and out of the law constantly, in and out of courtrooms constantly. But what I thought I saw the flavor of one of the reasons there was such a delay was that they needed, the defense counsel needed time to adequately prepare mental health experts, and if that's the case, isn't that really going to come in play during the sentencing phase in terms of the capital punishment phase, not so much in the guilt or innocence phase? Or maybe I have it wrong.
Well, they could use it in the guilt or innocent phase if they're going to try to say that they're not competent to stand trial, but they should have already alleged that, so I don't expect that to happen.
Yeah, I don't see that either, and again, you try to understand why this happened. This is such a tragic case where it seemed, and we're going to hear in the prosecution's opening statement, when a Marine was trying to protect his wife from a robbery. It was a fight outside of a bar. You see these kinds of senseless acts all the time, right?
Yeah, unfortunately you do, and sometimes it's like no good deed goes unpunished. You think you're doing the right thing and you're taking actions to protect someone you love, and you end up getting murdered, and that's what's happened in this case. It's really awful.
So we know that the gun that allegedly was used in this crime was traced to another robbery that these men might have been in connection with. When you have that kind of thing where a firearm is used in multiple crimes and it's used to connect defendants, is that an avenue for the defense to explore, saying, hey, listen, you know, how can we track the evidence properly? Is that an avenue for the defense to attack?
I think they can try to attack it. It depends on how well the prosecution proves the chain of evidence and says, you know, who it went to, when, and how. Yeah. And if they can prove that, yes, they had this gun and they used it, Ashley, then I don't know how well they can attack that.
Yeah, we're going to have to see. I'm sorry to cut you off. We have the opening statement right now by the prosecution, so let's jump in live. Okay, welcome back, everybody. We just heard a really compelling opening statement by the prosecution in this case. You just heard that one of the public defenders for one of the defendants has chosen to reserve the opening statement, but the other public defender will be speaking right now. So let's listen in live to the opening statement from the defense.
And clear. The identity that's in